The King Cast question of the day is, why is it that the most revered lawyers in New Hampshire get away with some of the sleaziest, unprofessional, and unethical conduct? That is the question. Part here where Justice Delaney, I believe, asks, well, I know it's her, and it is she. She asks the prosecuting attorney, Mike Delaney, look, how many times are we going to let this guy lie, this Joe Salvatore guy lie, the state's only witness? And in addition to the lies, in the first instance, you had Delaney, Kelly Ayotte, successor, okay? You had Delaney withholding information about the fact as to the date that this Salvatore guy obtained his gun permit, and then also he failed to disclose the fact that Salvatore had illegally fired a gun of the same caliber that killed the victim. And McLane Graf attorneys failed to put that second element into their motion regarding the prosecutorial misconduct. Okay, and that is unethical, and it shows a history of how McLane Graf operates with respect to black men in the judicial system. In my case, my Free Press First Amendment case, 2010 CV 501 against Kelly Ayotte, McLane Graf attorneys and Judge McCafferty, Magistrate Judge McCafferty, all failed to disclose the fact that she worked there, and she's looking at her former boss, the founding partner of the firm, and co-workers right across from me at counsel's table. Look, I'm a federal litigator. I mean, I was a federal litigator. I've been there, done that. That's ridiculous. You in New Hampshire ethics, judicial ethics state you have to disclose that because a person could reasonably consider that to be a moment of bias. Anyway, let's get back to this now. Yeah. Okay.
It's a wrinkle here, Judge, and there's no cases from this jurisdiction that has dealt with that, and my research didn't come across any cases from other jurisdictions in which lesser included offenses were not reached, but logic would dictate that could have happened. For example, if there's also negligent homicide charged here, that's a lesser included that the jury isn't necessarily determined in this case, given the way that the charges are given to the juries.
But apparently in Yeager, the court held that the second trial was barred on an offense for which there was no verdict. Is that right? The insider trading verdict? The insider trading charge?
Yes, but I believe the reasoning behind that was because essential elements of the crime, the court determined, were conclusively determined by the jurors through the verdict in which they reached an acquittal on a related charge.
Right.
And that was the issue in Yeager.
I mean, that sounds like it's an extension of Ash, though, because Ash was successive trials, and this is one trial, and so it sounds like it's a different rule that the court is applying.
Again, yes, I agree with Your Honor, and that's why the state's position that Yeager really is opposite to this case, with respect to double jeopardy and also with respect to collateral estoppel.
If he was charged with first-degree murder here, as he was charged, and that was all, and he was acquitted, you, the state, could not come back and charge him with reckless second-degree murder.
I agree, Judge.
Okay. Why should it matter that one's done in the same trial or a separate trial? What's the critical difference?
I think the critical difference here is that we do have one proceeding in which charges were at least submitted to the fact finder for their determination, and they are, as a matter of law, lesser included offenses. That the state, in your scenario, with later, seems vindictive for the state after an acquittal, when the state, the defense, and the court on its own could have submitted legally acceptable.
Well, what's the rationale, other than we don't like people to be vindictive, what's the legal rationale for not allowing a second indictment. You charge him only on first-degree murder here.
Oh, wait a minute.
He's acquitted.
See,
then you decide to bring...
it is vindictive, okay, because of what I just discussed, the withholding of evidence.
Bring a reckless second-degree murder in a subsequent proceeding. You say you can't do that. What's the rationale that applies there that does not apply in this case?
I think courts have always made the distinction, well, not always, have made a distinction between simultaneous prosecutions, which would be the situation in which you have a charge and also lesser included provided to the jurors, and separate successive prosecutions, which is the situation that you're talking about. And I think the underlying rationale would be there is some vindictiveness on part of the state, and there's also some public policy interest once those charges are submitted to fact finders and they weren't able to reach a determination.
It's not a double jeopardy problem, it's just a vindictiveness public policy issue?
Yes.
Well, isn't that the finality component of the double jeopardy clause that's at stake?
That's the public policy position that I'm talking about, Judge. It was recently discussed by the court in State v. Howell, a 2009 case, which talked about finality of judgments and public policy for fair trials.
Apparently, the indictments were issued following perjured testimony of the critical witness, and apparently he again perjured himself afterwards. You say there's no due process problem here with the perjured testimony, apparently all along the way.
Yes, just to get the facts straight here, Judge, there was an initial indictment. The witness perjured himself, admitted that to the state. The state then sought new indictments based on that, and then literally on the eve of trial, the witness gave a different version of events as to not the shooting itself, but collateral, where the shooting occurred. And once the state found out about that, they immediately notified the court, they immediately notified the defense counsel. The state also attempted to present charges to a new grand jury. But the judge refused to do that, and the trial was submitted based on those indictments. That was one of the reasons, since this retrial, that the state has re-indicted the defendant based on what was somewhat... there was some perjured testimony. It didn't go to a material fact, an issue that was presented to the grand jury. That would be one of the reasons it's not a due process.
But on top of that, we also learn after the trial the business about when the gun permit was issued. Right? So we have 2 episodes of perjury, and then we have
the withholding, too, which is not mentioned here.
Newly discovered evidence about when the gun permit was. I mean, is there not some point where we pile on this problematic testimony from apparently the only eyewitness?
I guess where should the blame lie? Should it lay at the witness who has repeatedly perjured himself, to the state as well as to the jury in this case? Or should it lie at the state, which has done all that it can with respect to this witness?
No, it hasn't.
The situation.
You failed to produce the other
testimony. We notified the defense counsel immediately, the court immediately, and we sought him.
Yeah, but you failed to mention the shooting of the gun beforehand, Mike. Mike Nifong, Mike Delaney.
Indictments. We raised these perjury issues before the jurors in the first case. All this was laid bare before the jurors in that case. The issue is whether or not this was prosecutorial misconduct that rises to such a level as to warrant a dismissal with prejudice. First of all, there was no prosecutorial misconduct, and the trial court below made an express finding with respect to that issue. And even assuming that there was prosecutorial misconduct, it doesn't rise to the level that warrants.
See, but the trial court didn't get everything because McLane and Graf didn't tell them everything. Okay, see how it works?
Dismissal of the indictments with prejudice under this court's authority and case law on that issue, in which it needs to be conduct on the part of the state which basically prompts a mistrial, and that clearly wasn't the case here. The mistrial was prompted by a jury's inability to reach a verdict on a submitted count. So it's our position that there is no due process violation. If the court has no further questions, I'll rely on my brief and respectfully request to affirm the judgment of the court below. Thank you.
Thanks very much.
Yeah. Kingcast.net, Judiciary.